I did that too. You know what he did?
I don't know, ma'am.
Ignored me.
What you have filed through the clerk's office, you're saying are matters in equity. We don't recognize what you're talking about in these filings.
This is a bank. This is a bank. I understand how the
What'd you say?
This court system operates like a bank.
Okay, it doesn't, ma'am. This court system doesn't operate like a bank in any way whatsoever.
Hold on, let me finish.
No. I'm not going to let you finish that particular statement.
I said I want to conversation. Don't want to argue.
I need you to.
I just want you to understand me mentally.
I did the mental thing just fine.
Okay.
I'm not worried about any mental thing.
Okay.
Judge Fish wastes no time. He denies Miss Butler's request to represent herself, calling it a calculated strategy to obstruct and subvert the court's proceedings. That's the ending. Let's rewind. Butler talks over Judge Fish, claiming to be the living man owed her estate with mean profit. He stays calm and explains she still has an attorney, so she can't also file her own paperwork. That's hybrid representation, and it's not allowed. Her filings get scanned in but struck from the record. None of it belongs in a criminal case. Butler insists they were private, meant only for the clerk. Judge Fish moves on, locks in a jury trial for August 18th to 19th, and warns her, miss it, and the trial goes on without her. Before wrapping up, Butler gets the floor and says she doesn't feel represented at all. Judge Fish didn't have to give her that moment, but what she says next changes everything.
Before we adjourn, Your Honor, I know Ms. Butler wanted to make a statement if court would allow that.
Okay, go ahead.
How you doing? The reason why I might have to let Mr. Pribble go because I'm not being helped with my case. There's a lot of violations that happen towards me. There's a lot of my evidence has been tainted, and it's a one-sided case. There's a lot of due process violations that occur, and no one want to listen. Everybody's being selective-minded, and I just want to address that to the court. I have so much evidence that I have presented in this court to show you, to prove to you, show facts, and also show you there's a lot of concealment within this court. So I'm asking you, can you address somebody to assist me in that matter?
Ma'am, we appointed the Porter County Public Defender Service, I believe, to represent you. Are you in this matter privately, Mr. Pribble?
No, I'm not.
So we appointed the Porter County Public Defender Service to represent you, ma'am. I appoint them and then they appoint a lawyer. So you've got Mr. Pribble involved in the case. You can't pick and choose what lawyer you get when you ask the court to appoint counsel for you. You get what you get.
I get that, sir.
Okay?
But only thing, the reason why I ask is because I feel like I'm not being helped. I see like I can do it myself and present this as pro se. But evidently, it's just being delayed continuously.
Well, ma'am, if you want me to do what's called a Feretta hearing and make a determination whether you can represent yourself without counsel, are you prepared to do that?
Yes, I am, sir.
Okay. I mean, I can do that Feretta hearing, but I'll let Mr. Pribble go for the day and I'll hold you until we're completed with the rest of our business. I'm not going to make all these other people wait while I go through a Feretta hearing with you.
Can I come back?
Come back when?
What time is it? Around 12:30?
Oh, no, ma'am. I don't have time at 12:30, but I have time around 11:30. Did you have a chance to review the pro se waiver rights form I presented you in open court?
I looked at it a little bit.
Did you sign off on that?
No, I did not sign off on it yet.
Okay. Would you like to have more time to review it before you sign it?
Yes. Can I get the second page, please? Because I have written on the back of it. You have a spare. I'm just gonna give me a whole new one. Can I also address something? You just let me know when I can.
Go ahead.
Judge Fish keeps hammering home the same point. If Butler wants to go pro se, she plays by the exact same rules as any attorney. No exceptions, no special treatment. Then he pivots to the actual documents she filed, talk of an office of executive, a final order to settle and close, and claims that the clerk's office has been quietly helping her sort out her accounting since May. He asks her directly whether she understands none of that belongs in a criminal courtroom. Butler doesn't back down. She says she's done her own research and believes she's uncovered real violations. Judge Fish presses again. Is this a criminal case or not? She agrees it is, but keeps circling back to her own theory of the system. This is where you start to see two completely different conversations happening in the same room, one legal, one not. And that gap is about to get a lot more obvious.
Explain a little bit
Document,
clearer.
These papers seem to indicate that you're trying to proceed in equity or under
Yeah,
some
that's
sort of
what
a
we-
pseudo legal jargon, some type of
Is we in the Article Court 3 right now?
say again?
Are we in the Article Court 3 right now?
I don't understand what you mean. This is the
Means
Supreme
that,
Court of Porter County.
okay, so we basically still in the same court as administrator. So you're basically trying to administrate a mistake. What I was letting you know.
Okay, Ms. Butler, you understand that these administrative things that you're talking about aren't part of this court proceeding?
I know, I'm aware of that. I was talking to myself, but what I'm saying is I have done some research, okay? And I actually wanted to address it. And I'm not getting no assistance with the public defender, okay?
What are you trying to address, ma'am?
My innocence of the matter, and also the violations, the due process, the unverified information, the lying, the evaluation. I've been forced to be drugged without a cell hearing. My evidence that was held from me when what's his name? Jeffrey Clymer had ordered the prosecutor to meet me in private to see my documents. I mean, the evidence held against me, and he refused to present them to me. That's a brand new violation because it worked in my favor when I first got it. Then also
Ms.
on the
Butler,
record.
I'm trying to get you through this
Hold on.
Florida hearing.
I know, but you asked me, and I'm trying to explain the violations, okay?
Right, but those aren't violations that are
They are,
part of this court proceeding.
now on this court
If
proceeding,
you have something that you plan to file related to that, it has to be filed through your attorney because you
And
still have attorney.
I did that too. You know what he did?
I don't know, ma'am.
Ignored me.
What you have filed through the clerk's office, you're saying are that matters in equity. We don't recognize what you're talking about in
You
these
guys-
filings.
This is a bank. This is a bank. I understand how the.
What'd you
court-
say?
This court system operates like a bank.
Okay, it doesn't, ma'am. This
It
court system
operates.
doesn't operate like a
Yes,
bank
it
in any way whatsoever. So,
Hold on, let me finish.
no, I'm not going to let you finish that
Okay.
particular statement.
I said, I want to
Because I
conference.
just
Don't
need-
want to argue.
I need you
anything.
to,
I just want you to
redirect it.
understand me mentally.
I did the mental thing just fine.
Okay.
I'm not worried about any mental thing.
Okay,
What I'm worried
okay.
about is the conception you may have that this is some sort of court of equity or some sort of a business transaction, some sort of a bank, something of that nature, because it is none of those things. You realize that? This is a criminal court.
Yes, it is. This setting is.
We're not an Article 3 court. That's a federal concept.
Yes.
You understand that?
Yes, I am.
Okay, we're an Article 7 court, if you must know, in the state of Indiana, separate judicial branch,
Yes.
not any of the things that you've said here.
Yes.
So what I need you to tell me is
Okay.
whether you are understanding that you have to follow, if you're going to represent yourself, you have to follow all the rules and regulations that are promulgated by the courts of Indiana. You have to follow the criminal rules. You have to follow the trial rules.
Yes.
Will you do that?
Yes. Yes. Yes.
We'll do that.
Yes.
So you understand that what you filed yesterday can be stricken under the record. Under the trial rules, under Indiana Trial Rule 12F, because it's impertinent to anything that is going on in this proceeding. You realize that?
I understand that in a sense, but like I keep explaining to you, it was not supposed to be filed in the court.
I know. You need a second to process that. Take a breath, hit subscribe, and let's keep going because it only gets better from here.
That's the difference.
You filed it at the clerk's office.
Yes.
Well, let's carry that out for a
Yes.
minute.
It's a difference.
What's the name of the clerk's office?
The court's office is the Clerk of clerks.
Uh,
Clerk of clerks.
Clerk
Yes.
of courts, right? So there are
Yes.
clerks. So if you
Yes.
file something that, and you have a case pending, they send that to your case. Unless you try to open a case of your own,
No.
you're trying to open litigation of your own?
No.
Okay.
What I am.
This has to be presented in your court case here that you have pending before us.
Okay.
you're
So
telling
you will
me
not
to
strike
follow
it?
the rules.
You won't strike it down, or you will strike
Oh,
it?
it has to be stricken. It is impertinent to anything we're doing here. You understand?
No, I don't understand.
Okay.
How you
You
just
have
strike-
filed documents making commercial demands, demanding accountings,
Yes.
challenging the capitalization. No, you didn't do that, but challenging different things about who you are and who you would in equity
Yes.
minister to,
And for
those
me-
kinds of things. Ma'am, you understand those have no basis in Indiana criminal law.
Okay.
You realize
But-
that?
But let me explain. Can I make a statement to you then? You said there's no basis in criminal
Go
law.
ahead. What's your statement?
Well, I also want to say something. And I also am a minister, and I want to read this on the record, okay? And it states that should a man prove himself to be living and not dead, nor loss of sea, his estate must be returned to him with mean profit. I am the living man that has a womb. I have accepted appointment of this office of executive. As such, this office gives notice of its authorizations and findings. And now I have issued orders, okay? And in the scripture, the living and the spiritual man judgeth over all things, yet he shall be judged by no man. And that's 1 Corinthians chapter 2, verse 15. Like I said, I came here with clean hands. And I'm now the executor. My estate has no longer been abandoned. And I don't allow no more trespassing and interloping upon and administrating it. I discovered a lot of things along the way, put me in this position.
Okay, ma'am. Clean hands is an equitable doctrine. You understand that? This is not a court of equity. If you were in a court of equity, you wouldn't even be given or afforded the right to a jury. I think it's appropriate for me at this time now to terminate the Ferretta inquiry, deny your request to proceed pro se. I'll specifically find that the request is not a genuine attempt to present a legal defense, but a calculated strategy to obstruct and subvert the court's proceedings. The defendant's utilizing rhetoric of what would typically be called a sovereign citizen movement,
No.
including raising nonsensical
No.
challenges
No.
and attempting to apply commercial law to criminal prosecution
No.
or equitable law.
No, that's not
Ma'am, you
true.
keep saying no, but you're talking over me and I don't appreciate it because I'm trying to rule. The right of self-representation is not a license to abuse the dignity of the courtroom or nor relevant rules of procedure and substantive law. Based on the defendant's filings and her statements in open court, court finds she's unwilling to comply with rules of procedure and intends to use self-representation solely for deliberate disruption of the proceedings. The request to proceed pro se is denied and appointed counsel will remain on the case. We're adjourned.
Judge Fish gave Butler room to speak, then made his call once the pattern became impossible to ignore. I'm going with Judge Fish on this one. Patience only stretches so far when a hearing keeps getting pulled off track. Was denying self-representation the right move here, or should she have gotten the shot? Let us know in the comments. That's a wrap on another epic case, and honestly, I have so many more where that came from. Drop a comment and tell me what you thought, and make sure you're subscribed to Court with Mia so you never miss the next one. See you there.